you'll notice that there's a section in the Landlord's Guide to the Fair Housing Laws. It's called Minimizing Liabilities. Without turning to it right now, let me just tell you one thing that you really ought to consider doing now, if you haven't done it already. In my opinion, because so many of the mistakes that we make as housing providers in the fair housing law come from as a result of a lack of information, uninformed decisions, you need to connect yourself with either a local or national housing organization that can tap yourself into a network of information. So for instance, the Northeast Ohio Apartment Association, NOAA. I think you should call them, 241-1635, and give them a call, because that's the very kind of organization that you should think about affiliating yourself with. It's not just for really big companies. It's especially tailored for those small organizations that in fact are trying to run a profit, but at the same time maintain and keep up with, the laws. You can't do that if you don't know how the laws change, and frankly, they change all the time. In the last 8 years alone, for instance, the Department of Housing and Urban Development has issued 3 sets of guidelines for occupancy standards. And, if you didn't know that, well, I'm telling you that right now. And frankly, that's very confusing to many property owners. How many people can I say are permitted to live in this unit? Is it 2-person per bedroom as a general rule? Is it a flat rule? Is it less or more? Well, HUD changed their mind 3 times. They're not sure. If they're not sure, you should be a little worried. So you want to make sure that you're informed. The way that you keep informed is by affiliating yourself with NOAA. And the other thing is this. You should do that for another reason. And that is that to the extent that you can, you want to avoid having to call an attorney every time that you have a question. Why? Let me explain to you, for those of you who have not had this experience, why. At Ulmer & Byrne, we put out an excellent product, but our barter is our time. So every time you call me, there's this little light that goes on my phone, and this little timer that goes on, and the minutes and the seconds start rolling. And I'm responsible for billing 2,000 hours a year. So I've got to make sure that I bill those hours accordingly. And frankly, you're billed for that time. Now, sometimes it's worth it, but sometimes it isn't. Fundamental questions you can get answered for yourself for free if you're part of an organization like NOAA. More detailed ones, you might need help. Anyway, let's get back to the Fair Housing Act. The solution. You need to provide a system for your employees within which you can operate. And the reason I'm bringing this up now is the key to that is that you not only need to emphasize fundamentals, but you have to know the basics. Not only that you have to make sure that the employees know the basics, the owners have to know the basics of the Fair Housing Act. Because if you know the basics, what you're doing then is you're providing objective guideposts for everybody in your organization, whether you're an organization of 1 or whether you're an organization of 500. I want to explain to you right now what my theory is in terms of how to learn the Fair Housing Act best. And the way that I look at it is this. I have a very good friend who manages properties in Cleveland and in Michigan. Sometimes she goes over to Florida. And she always tells me that, you have to begin with the end in mind. Start with the trial court and move backwards. Why do I say that? Well, as an attorney, there's a process that we go through when we ever litigate any kind of case. But when we litigate a fair housing case, we do several things. Now, you're not going to be able to read this, but I'm going to explain it to you. And for those of you that have the chart in front of you, let's work off of that. What I did here is this is a fair housing litigation flow chart. And you'll notice that there's this sheet. This actually says judgment, and then there's an arrow pointing to it, and it says verdict, and pointing to that is jury instructions. What does this all mean? Why do you need to know this? Well, the reason I'm telling you this is the following. When you litigate a fair housing case, when you're looking to see whether you can successfully defend or prosecute a claim, you start from the end and work backwards. And the first place you look are the jury instructions. Why? Because the jury instructions set forth exactly what needs to be proved in order to have a successful claim. So you need to know, in a layperson's manner, what the jury instructions are for each claim that comes your way or for each potential situation you may be dealing with. Let's talk about what I mean further. Go to your section that says the Fair Housing Act flowchart. If I work with the end in mind, the first thing I'm going to ask is, well, what are the remedies for a person who comes forward with a fair housing claim? I mean, really, what can they recover? What's my exposure initially? I want to talk about one case. I talk about this case every time that I lecture. The reason is because it's every bit as pertinent as it was in 1974 when it was litigated before the Supreme Court. And that case is Curtis versus Lothar. Julianne Curtis, she goes to look for an apartment, suburban Chicago. She runs into a man named Robert Lothar, who's the owner of an apartment building. She is told, I'm sorry, I can't rent to you, Miss Curtis, because you're African American. Actually, he just said, I don't rent to black people. Okay, the apartment in question was $300 a month. Julianne Curtis goes right next door, and she finds a place from another person for $310 a month. So the question becomes, how much is Julia Ann Curtis out? How much? Both were year leases. One was for $300 a month, one was for $310. Somebody say 120? Right there. 120 bucks. Cut her check for $120. We're done. Sorry I did that. Didn't mean it. We're done. 1974. How many of you think that that, in fact, is all that Julianne Curtis would be entitled to? Nobody's raising their hands for the cameras and information. And I agree. $120. Julianne Curtis litigated this case. She took it first to the district court in the Seventh Circuit Court of Appeals next, and then it went to the U.S. Supreme Court. And initially, the reason it went to the U.S. Supreme Court wasn't about how much Julianne Curtis was out. It was about another issue. It was about Julianne Curtis saying, look, we've got a problem here. I am an African-American woman living in a racist society. And because I'm an African-American woman living in a racist society, and because most federal juries are all white, I will not be able to get a fair trial if, in fact, a jury trial is permitted to go forward in federal court. And therefore, no one should be permitted to have a jury trial in fair housing cases. Now, Robert Lothar, he steps back along with his lawyers and says, wait a minute. The Seventh Amendment, which for those of you that don't know is the right to trial by jury, that applies to everyone, whether it be as a fair housing defendant or a fair housing plaintiff. And the Supreme Court, in a decision written by Thurgood Marshall, decides for who? Any ideas? Somebody, you got a 50-50 chance. Yell out Lothar or Curtis, somebody. Curtis, okay, you've heard this before. And that's right. Julianne Curtis actually lost because she wasn't entitled to a jury trial. So you're actually not right. She said she wasn't. The court ruled for Lothar, who said that you were. But what's important about this is this. Not only is a jury trial, Seventh Amendment right, extend to the Fair Housing Act, but there was a footnote in the opinion written by Thurgood Marshall. And what Thurgood Marshall said is, you know, the Fair Housing Act is a little different than any other civil rights act out there. Because what we're talking about isn't simply a right to rent property or buy property. When someone is denied that right, we're not talking about actual damages, you know, how much they're out of pocket. We're talking about what's called the concept of a dignitary tort. A dignitary tort. Remember why the Fair Housing Act was passed. It was passed initially in 1968 to, and these are not my words, these are Potter Stewart's words, to eradicate the badges of slavery. Every law is based on an amendment to the Constitution of the United States that we pass. The 13th Amendment, which abolished slavery, is what the Fair Housing Act is based upon. It was passed originally to eradicate the badges of slavery and this is particularly, I think, relevant for the citizens of Shaker Heights, to promote balanced, integrated living patterns. Some people have forgotten that message. I'm probably as strong an integrationist as you can get, but having said that, Julianne Curtis didn't get $120. She was entitled in 1974 to $10,000 for that denial. Is that enough money to erase the memory of what occurred, to erase the memory of being treated differently because of some immutable characteristic? No. It never will be. And that's the problem that you face when you treat somebody differently, whether it be intentionally or not, because I don't have to prove that you intentionally went out to hurt someone. I just have to prove that you treated somebody differently. And whether you had a system or not, no one's going to care. Julianne Curtis and damages. Now, Lisa Gale had mentioned earlier that you're entitled to injunctive relief. In addition, does everyone know what injunctive relief is? Shaking your head, okay. What it means is the court orders you, no, stop doing that right now. Cease and desist, or we're going to freeze the status quo. We're going to make this apartment, for instance, that you wanted to rent to potential tenant A, we're going to make that completely open until we resolve this litigation. Injunctive relief is a very, very important tool in the fair housing arsenal. And why is it important? Because when someone applies for injunctive relief to take your unit off the market, so to speak, they can get what's called a motion for a preliminary injunction granted, and what that requires is a preliminary injunction hearing, which is a mini trial, which would take place within 15 days, 20 days of the filing of the complaint. It's not some long, drawn-out process. It happens immediately. So that's the remedy, or part of the remedy. Now, aggrieved person. If you're going to know, or if you're going to realize how to understand and read a law, you always start with the definition section. If you look at section, and you have the Federal Fair Housing Act in front of you, but if you look at section 3602 of the Federal Fair Housing Act, that's the definition section. And I think that's very important, because that's going to answer some questions that you might have about what constitutes a family. It's not just somebody who has children. It's a pregnant person. It's someone who's in the process of obtaining custody. It's also somebody who might be the designee of a parent. Okay? But that page would be located on first page. Yeah, it's section 802 of the Act, but it's also, it's codified at 42 U.S.C. section 3602. In addition to that, what I find is very interesting is this section of the law defines what rent means, okay? For those of you who think, well, you know, I'm actually not a property owner. I'm a tenant, and I'm going to be subleasing this summer to someone. But I'm going to tell you one thing. I'm not going to sublease to anybody if I find out that they're HIV positive. Because this is my place. They're going to be using my utensils. You know what? First of all, persons who are HIV positive or who have AIDS are protected by the Act. Second of all, subleasing is also included in the definition of to rent. So, if you sublease and you discriminate, you're on the hook too. Just so you know. Now, many of you that doesn't apply to, but it does apply to you in terms of the protections of the Act as they apply to persons who are HIV positive, persons who have AIDS. Now, somebody once said to me, well, what about persons who are gay? What about them? Are homosexuals, for instance, are they covered by the Act as defined by the Act? No. No, they're not. But I would be very careful if I were you, because if you look at our definition section, let's flip over to the second page. First of all, bottom of the first page, look at the word handicap. That's 3602H. Now, handicap is defined as a physical or mental impairment which substantially limits one or more of such person's major life activities. Now, there's a second definition, a record of having such an impairment. And then there's a third definition, and I'd like you to focus on that third definition, being regarded as having such an impairment. I'd be careful because, you know, the reason the Fair Housing Act was first passed initially was because we were going to end discrimination and also end stereotypes. Stereotypes. You know, there was a book that once came out that rated property values according to what your ethnicity was. Swedish being the best, Slovak being the worst, Eastern European. I would argue that if you were to make the decision that you were going to have a policy that said, I don't rent to homosexuals for whatever reason, you would possibly be violating the Act anyway, because I think you could make a very strong argument that there's a stereotype out there that casts persons who are gay in a light where, well, you know, all persons who are gay, they're also HIV carriers. And then you'd be treating someone as having a disability. You would be regarding them as a person with a disability, and as a result, you'd be in violation of the Act. So I'd be very careful. I'd think hard. Act in haste, repent in leisure. I mean, think hard before you act on that one. That's for certain. But the definitions are more than just informative for that reason. If you look right below that section, there's a definition of what an aggrieved person is. And this is very important, because an aggrieved person isn't just someone who is the victim of the discriminatory act. An aggrieved person also is someone who believes that such person will be injured by a discriminatory housing act. Now, when we talk about the history of the law, that's why we get into Paul Trafficante. Because Paul Trafficante in the early 70s was an individual who actually, he lived in an apartment complex where he noticed there was unlawful steering going on. You know, we're steering the black residents over here, we're steering the white residents over here. And he filed a fair housing claim arguing that he was being relegated to living in a white ghetto, even though he was white. The Supreme Court agreed with him. He had standing to sue. He had the power to bring a claim. In any event, I want you to make sure that you know what the definitions are, because if you don't, you're not going to know whether they apply to certain situations, which brings us then to the discriminatory housing practices. Okay, we know who's protected. We know what the definitions are. But what is it that we can and cannot do? All right? There are different sections of the law, and I'm going to be using the Federal Act for the purposes of this section of the law. and of the lecture. 3604 is the section that you want to initially refer yourself to, and that would be located, for those of you that need a page number, it would be beginning on page 5. Thank you. Page 5. I call 3604A my refuse to rent section, okay? That's all I call it, rent sales. Why? This is where you refuse to sell or rent a unit or otherwise deny someone tenancy because of that person's membership in a protected class, period. I don't think it's that much more complicated. A 3604A claim. Now, here's where we get into some differences. What's the difference between 3604A and B? I call B my rules section. Why? Because the same rules have to apply to all of your tenants. You can't have one set of rules being enforced against a group of one set of tenants and another set of rules being afforded to another group of tenants. All the rules that you have to be equally enforced. Otherwise, you're going to be in violation of the rules section, the terms and conditions section of the Fair Housing Act. 3604C. I call this section the statements section. It also deals with advertising. We'll get into that. By the way, how many of you advertise in the paper? How many of you do not? How many of you just post a sign? And how do you actually rent if you don't advertise? You let Judy Steeler do it? You're in good hands. Well, for those of you that do advertise, make sure you know what this rule says, because what it makes clear is that you may not print or publish or cause to be made, printed, or published any notice, statement, or advertisement which indicates a preference, limitation, or, as the Act says, discrimination based on a membership of a protected class. Example: mature males preferred, or mature persons. Let's go with mature persons. Mature persons preferred. I got a two-family house. Look, I don't want families with children, but I went to this fair housing lecture, and I listened to this lawyer from Ulmer and Byrne, and he said that I couldn't say, well, no kids when you walked up the door. So I've got an idea. I'm going to put a chilling effect on families with children by applying to my apartment. By what I'm going to do is I'm going to put in this ad, mature persons preferred. And by doing that, I'm going to put myself in a position where I'm going to minimize the amount of applicants that come my way who are families with children. That is against the law. And in fact, I have on page 20 of the question and answer section of your Landlord Guide to Fair Housing Law, that very example. And this was an actual case. This was HUD versus Janik. And this is an actual ad. North Lake Deluxe, one-bedroom apartment, air conditioning, newer, quiet building, pool, parking, mature person preferred. Credit checked, $395. This violated the law because you may not ever publish an ad that suggests to an ordinary person reading that ad that a particular group or type of person is preferred or dispreferred. It's against the law. All of this simply by looking at the statute, which is amazing to me. Some people never do. I had one case that I was investigating with the city of Shaker Heights not too long ago, where we had this was a multi-unit building, and the policy was no children on the second floor. And the justification was, well, we have an obligation per our lease to protect each tenant's quiet enjoyment of the property. My response to that was, Mr. Property Owner, we can do this the easy way, or we can do this the hard way. The easy way is we're going to settle this right now. The hard way is we're going to make you spend a lot more money on attorney fees, and we're going to end up winning the case anyway. We resolved that case. And the reason we resolved the case, frankly, is this individual had no idea what his obligations were under the law. And as part of that remedy, we required him to go to training. We required him to actually go to one-on-one training. And I still don't know if I got through to him. But anyway, 3604C. 3604D. I call this section, and I have to give some credit to another lawyer. This is called the lies section, as an L-I-E-S. This is where you're lying. This is where you say, you know, this section, you know, our apartment, it's not available. When in fact it is available. You lie. You make a representation that one section is available when in fact it is not. Now let me give you an example of where a failure to have a system could get you into trouble, and even in this area. Let's say you have 3 employees working on a property. Or let's say you have 3 employees working on a property. I'm trying to make sure that applies to everybody in this group. Or maybe you're a husband and wife, and you have a single-family home or a 2-family. But you're not all on the same page. One of you really handles things, okay? I mean, as in so many relationships, one of us is more organized than the other. I think we'd all admit that. Usually it's not the men. But in any event, one of us is more organized, and there's no communication, though, that's taking place between the 2 or 3 of you, and as a result, one day, there's a phone call that comes in, and Bob, he picks up the phone, and he says, "Hi, can I help you?" And he says, "Yeah, I'd like to know if the ad that you're posting here, you know, if the apartment's still available." "Yep, sure is. You know, come on down, take a look at it." "Are you positive?" "Yeah, I'm positive, no problem." So, you know, hang up the phone. Bob never tells his wife, Mary, what's going on. Mary has no idea that Bob's just made this communication, even though Mary is negotiating a deal with this one individual to rent the apartment that's the subject of the inquiry. Okay? So then what happens next is the person who made the call to Bob, she comes visiting. And Bob now realizes that, well, gosh, you know, Mary was negotiating, so I guess, you know, that's no longer available. So he tells this woman, who's black, that, in fact, the apartment is not available anymore. Now, Bob doesn't really have an idea of whether or not the apartment has been rented. Turns out that it wasn't rented. There was no application taken. Mary just kind of made a passing comment about this, so Bob automatically assumed. So Bob makes a representation that, in fact, the apartment now is no longer available, when, in fact, it was available. Now, the next day, this same person, kind of being a little suspicious because Bob's so, you know, almost like an airhead. He's so disorganized. She makes a call again, and this time, though, she identifies herself as someone else, just to see if it would change the situation. And this time, Bob, after getting on the same page with Mary, says, "Yeah, we got a place. Come on down." Even though Bob maybe didn't lie, maybe he's got a defense that he's just disorganized, I wonder how many of you would like to try that case before a jury. You got a problem. You got a problem because you're not on the same page. Put yourself in a position where you can all be on the same page. Otherwise, the Truth in Housing section, 3604D, even though you're not going out and lying, it could apply to you. It could apply to you. Now, it's not just about lying. If you take a look at 3617, I want to go back to another section, which is on page, help me out, Lisa. That'd be section 818, page 29. 3617. And by the way, all of these provisions also are contained in the state and local ordinances. Okay, so you don't worry about, I'll tell you if there are differences between the acts. in terms of federal, state, and local law. What I'm describing to you, though, right now applies for all the different laws, okay, that we went over, which would be the local ordinance, the federal ordinance, and the state ordinance. How many of you, though, just out of curiosity, own 4 or more units in the city of Shaker Heights? Raise your hand high. Okay. For those of you that do, I want to make sure that you do something for me after you leave here today. And the reason I want you to do this for me is because if, in fact, I ever have to come visit your building, one of the things I'm going to want to know is whether you're complying with Section 515.05 of the Shaker Heights Fair Housing Ordinance. If you look at page 17 of the question and answers, you'll notice that for persons who operate or manage a dwelling with more than 4 dwelling units, so actually you can actually have just more than 4 dwelling units. You don't have to have 4 buildings. You need to post this certain sign, which states on a light-colored background and not less than 14-point type, it is a violation of the Shaker Heights Fair Housing Law in connection with any housing activity to discriminate against any person because of race, color, religion, sex, ancestry, handicap, familial status, or national origin. For more information, contact 491-1440. Do yourself a favor. If you own or operate more than 4 dwelling units, get your computer or have somebody print out a sign that says exactly what we have here contained on page 17. And it'll save you one less headache in the event you are ever a respondent in any kind of action that deals with the city of Shaker Heights, okay? That's a section of the law you should absolutely comply with under any circumstance. 3617. Back to page 29.
Where do you post that?
If you take a look, you should post it in a conspicuous location in those areas or places of business where prospective purchasers, sellers, or renters normally make inquiries, or where the terms of a sale or rental are normally negotiated. So, for instance, if you have a rental office, clearly, it should be posted there. Somewhere it can be seen to the general public when they come in the door, okay? If you have just a vestibule, if this is a 2-family, I'd post it there in the 2-family, in the vestibule, okay? It's going to be where that potential tenant is going to be walking in the door so that they can see that, and they can see that you practice fair housing. You know what? It makes great sense, because if you do post this, I feel a lot better about you as a respondent when I do investigate a claim that's been filed against you, when I see, you know what, Bill, here's our policy prohibiting unlawful discrimination. This is what we believe in. Here's our posting that we have right here. That we always make sure that every tenant has an opportunity to see. We practice fair housing. We believe in fair housing. We might have made a mistake here, but it's not unlawful discrimination. And there's another reason. In the event you are ever held to be liable under the federal, state, or local law, one of the remedies that's available, which I should have mentioned, are punitive damages. Now, punitive damages, they don't actually have anything to do with what you're out of pocket. They're there to teach the wrongdoer a lesson. They exist to deter other people from engaging in that kind of conduct. And if you have policies in place already, if you have the posting that you're supposed to have in accordance with the Fair Housing Ordinance in Shaker, what you can make a very good argument towards is, hey, look, we may have made a mistake here. We may not be as organized as we should have been. But I'll tell you one thing that we're not. We're not going out and we're not intentionally discriminating against anyone. And here's the evidence of that fact. And in fact, I can show you cases where the court has taken into account individuals who have, in fact, had fair housing trainings for their employees, have, in fact, posted fair housing posters, and as a result did not have punitive damages awarded against them. It's very important. It's also the right thing to do. But in any event, 3617. You know, I've never been to the Shaker Heights Police Department, but with this light in my face, this is like my vision of what it would be like if I was being interrogated by Miss Gale. Sorry, Lisa. Anyway, I can't see. 3617 is what I would call the retaliation section of the law. And it applies to more than just the situation where someone complains to you about what they perceive to be unlawful discrimination, and as a result, you give them a 3-day notice and you're ready to evict them. Clearly, that's retaliation. It also applies to the situation where the employee observes unlawful discrimination taking place, objects to it, and is terminated, and it loses their job. They can also bring an action under the Fair Housing Act per 3617 or Section 818 of the Act. This is a very important part of the law that I think goes unnoticed, and it also goes unnoticed for another reason, and that is that actually there are criminal penalties that are they're linked to 3617. And I take you again to the question and answer section of the guide that we provided to you today. Let me find the question itself. Yeah, if you look at the bottom of 22 and the top of 23, and particularly just the answer section right now of 23, what you'll notice is that I've cited not only Section 818 of the Fair Housing Act, which is the anti-retaliation provision, but I've also pointed out that there's another federal law that makes it a crime to use force or threat of force to interfere with or intimidate a person attempting to exercise his or her rights under the Fair Housing Act. Now, what do I mean by that? Everyone in this country has a right to live where they can afford to live. Everyone. And that extends not only to the rental of units, but also to the sale of units. So if you were to buy a home, for instance, and this was a case that I had, and it was a very sad case. It was one of the first cases I had when I was getting involved in the practice. And the house was purchased in Little Italy, and the neighbors objected to the fact that the tenants were Chinese. And as a result, they started to utter ethnic slurs against their new neighbors. You know, it's not only a violation of the law civilly, it's a crime, especially when they start giving them hate mail. You know, this extends to cross burnings. This extends to so many of the things that we find reprehensible, that we don't think goes on in our society, but unfortunately, in certain segments, continues. And that's why the Justice Department, who would enforce this, can bring the full force of the federal government against any individual who would do this. Now, I know, and I'm preaching to the choir here, that none of you would ever think about doing that. But there might come a time when you have someone who is a neighbor who doesn't understand what they're doing, and you may want to be able to remind them of that very fact, that we can do this the easy way or we can do this the hard way, because you are protected by the law. If you're trying to extend someone the right to live in an apartment or a house free from discrimination, and another person attempts to interfere with your ability to provide that housing, you actually can bring a claim as the housing provider. So keep that in mind as well. Now, what are we doing on time? Okay. We're going to get to accommodations and modifications in a moment, which is really an area that I think causes a lot of confusion for property owners and a lot of concern. Before we do, I want to talk about one fundamental fact, and is this. Whenever you look at these kind of claims, make sure that you create what I call a bridge, building a bridge between a protected class and an unlawful housing practice. And what I mean by that is this. When you are in fact doing your own analysis. You have to identify if someone's a member of a protected class. And then you have to say, all right, it is unlawful to, for instance, refuse to rent, and then you have to put in these two words, because of that individual's race, or because of that individual's national origin. Without that because of phrase placed in your thinking, in your sentence pattern, you're not going to be able to have any kind of logical framework that's going to help you here. And you'll see that on this chart, that's exactly what I've done. You know, you have the protected classes on your left. And remember, as I pointed out, Ohio and Shaker have 8 protected classes. Federal law, we have 7. Because of that person's race, I refuse to rent or sell to them. Or because of that person's familial status, which we all now know what the definition is, I hope, if you look at the definition section, I refused to provide them a place to live. Or, you know, if you want to get more sophisticated, you know, because of that person's familial status, I made a statement where I placed a limitation on their ability to rent the place. You need to be cognizant of that. Now, you'll notice in 3604, let's go back to that section, and then we'll take a break. 3604F, I'd like to direct your attention to, which is located on page 5 and 6. And I'd particularly like you to look at actually page 6. Reasonable modifications versus reasonable accommodations. Since 1988, and I think even since 1990, even more importantly, since the passage of the Americans with Disabilities Act, employers, housing providers have had to sensitize themselves to a group of people who really are entitled to the same rights and enjoyments and living in a property as anyone else, and that's persons with disabilities. Now, in 1988, the PC was handicapped. Now it's persons with disabilities. But as a person with a disability, you are entitled to have certain modifications made to your unit so that you can have equal access and enjoyment of the dwelling. One of the questions that comes up, though, is, all right, Bob Tennant, who is handicapped and is confined to a wheelchair, he comes up to me and he says, Bill, I'd like you to make a reasonable modification to my unit because I am a person with a disability and I am a member of a protected class, and my reading of the law says that you have to allow me to have equal access to the unit and so I can enjoy it as anyone else, and therefore, because I can't fit through the doorway to the bathroom, I want you to widen that doorway, and I want you to pay for it. Now, you didn't have any problem with the first part of that request, probably. But the second part kind of concerns you. You know, gosh, I mean, I got two-family home here. Widen the unit. I mean, how much money is that going to cost? I mean, I don't even know where to begin. I mean, do I have to, like, provide this request? Am I going to get sued? Am I going to have Bill Edwards snarling down my neck because I violated the local ordinance and the Federal Fair Housing Act? You know, this is a basic, guys. If you don't know the answer to this, I'm really glad you're here. Who pays for the modification? The tenant or the property owner? Who thinks that the tenant has to pay for the modification? Who thinks that the property owner has to pay for the modification? Who's not sure? See, I always say not sure. All right. I'd like to direct your attention, and I want to find the example All right. I want you to look at page 19 of the question and answers. Now, we're talking about reasonable modification. And I think that you've got to get this in your mind. Modification means you're actually modifying, changing the physical structure of the unit, whether it be in a common area or whether it be in an interior dwelling unit. Okay? Modify. Bob Tennant wants to know what my answer is, and I'm going to tell him the following. I'm going to say, well, here's what we need to do. First of all, absolutely, we will widen the doorway. But we're going to have to do a couple things. I don't know if you're aware of this, but it's your obligation to pay for that modification. And because it's your obligation to pay for it, I want to make sure that it's done properly. So the only thing that I can insist on is I want to make sure that we get a professional building contractor in here to take a look at it. I can't, as the property owner, choose who that is, but I need to make sure that we get someone in there that is mutually agreeable to both of us. Okay? So actually, the truth is that the tenant pays for that restoration. So those of you who thought it was the housing provider, you might be relieved. Now, here's the question that we get into, though, is, well, is there any way that I can have any kind of assurance that I can restore the property back to the way it was? I mean, what if this person, asked for this, wants grab bars placed in their bathroom, in addition needs a ramp that's placed outside in the common area, and all those things are taken care of, but what assurances do I have if I want to ever change the unit back that, in fact, I can do that? Can I ask, for instance, for a restoration deposit from the tenant? We'll answer that question after a 5-minute break. We're back, and we were asking the question whether or not you can insist that Bob Tennant restore the doorway to its original width once he vacates the premises. I have to apologize to you. There's another section of information that you need to look up, and we should have provided it to you today. But there's just so much to know. And that is, there are regulations that are promulgated and issued by the Department of Housing and Urban Development, and they're found in your Federal Register, 24 CFR Part 100. Part 100. You can get that at any library. Look them up. And in fact, I don't know if there's a lot of apartment. Can we provide those to people who need them?
We can get our hands on them. We don't have them in our department, but we can have access to.
I could get my hands on them. If you want, you can call me. I won't even charge you for it. Really. 24 title, 20, it's the title of it itself. You're going to find it under Housing and Urban Development. 24. And it's Part 100. And the reason I say that has everything to do with the next answer to our question, which is, can I insist that Bob Tennant restore the doorway? Okay? In this instance, the answer is no. The answer is no. I can't. In certain instances, I can. But what I have to do is I have to make sure that I look up the regulations, which provide examples of what's permissible. For instance, I can ask for Bob Tennant to pay a restoration deposit so that I can take the grab bars off the wall. But I can't ask for him to do anything that would be more of a chilling effect on his ability to use the property, which would be, in this case, paying for that restoration of its original width. Be careful when you think about restoration deposit, which is the next topic. And we're going to go, I know I have a question from a gentleman over here about, well, can we talk about what really constitutes reasonable, in these instances? And we'll talk about that in a moment. But in order to guarantee that certain modifications can be made, you may ask for money to be placed in an interest-bearing account by the tenant, which you would have authority over, which could be used towards, the restoration process. The question that you have to do, though, you have to address, though, is whether or not your request is a reasonable one, and there are a number of factors that need to be considered. And unfortunately, in many instances, the reason that the word reasonable is used is because the legislators, the Congress people that were writing these laws originally, they weren't sure themselves. So they used the word reasonable. And we've been litigating and arguing about what the word reasonable means ever since. You may not like the answer to that question, but that's true. Now, in terms of what constitutes a reasonable restoration deposit, there are factors that are delineated in the regulations that deal with what you need to look at in order to assess how much you would ask for, whether you would ask for anything in the first place. So, for instance, the nature and extent of the modification would be one. The duration of the lease, how long is this person going to live here, would be another. The credit and rental history of the tenant would also be another, in asking for a for a restoration deposit. What you want to be careful about, and I've listed those factors on page 20 of your question and answers. What you want to be careful about is asking for a restoration deposit that will serve two purposes. One, which you may only recognize. The first purpose being, in your mind, that it would be simply to have the unit restored to its original condition. But the second effect it may have is to actually place a chilling effect on that tenant from even asking for the modification in the first place. You have to be careful, because if in fact you ask for a restoration deposit after a request has been made for a modification, and then the tenant says, well, gosh, I can't afford that, forget it, and they go talk to somebody about it, there's an argument that you have actually retaliated against that tenant by asking for an unreasonable restoration deposit, so that you would be in violation of the law. Okay? I've worked both sides of the fence on this, so that's the argument, at least. So, in any event, I'd like to talk about reasonable accommodations, because now we all know that if we're modifying a unit, who pays for it? The tenant. Okay, we all know that. It's at the tenant's expense. Now, what about your rules, your regulations, your policies? What happens when someone is disabled and they ask you to modify your rules and regulations so that they can have equal access to the property and full enjoyment of the property? Let me give you an example. And take a look at page 18 of your question and answers. Bob Tennant is still very popular in my mind, I guess. He's disabled, he's living on a property you manage, he's confined to a wheelchair. In March 1998, he asked you to assign him a reserved parking space, placing him at the top of a waiting list in which he would normally place at the bottom. In fact, there are 20 people that are ahead of him who are all going to be really ticked. And tenants can be so subtle when they're really ticked about what, in fact, they want. Well, now he's at the top of the list, at least he wants that. And he comes to you and he says, I need this accommodation. Are you going to grant it? Now you've got the answer right in front of you. That's yes, but I'm going to give you another fact scenario. Let's say that instead of wanting a reserved parking space, in this instance, Bob Tennant, he's not handicapped, at least physically handicapped. He's got a mental disability. He's got a severe case of schizophrenia, but he has a pet, and the pet calms him when he goes into these periodic phases. The pet brings him comfort. You have a no-pet policy. There are no exceptions to your no-pet policy. gee, let's say you're a two-family house owner. I mean, look, I may actually live in this property someday. I mean, our kids, they'll move away, we'll sell the one property, we'll move over here, we'll stay here for a little bit before we all abandon Ohio and go to North Carolina or Ohio, Florida or wherever. I got this one person laughing, I know it's the plan. And you know, everything will be peachy keen, but have you ever seen a house after a dog has lived in it? There is hair everywhere. It is disgusting. My wife made me clean for 3 days when we moved into our new house. That's when I said, you know, maybe we should get your parents to come in. Anyway, you have this no pet clause. You have this person who is arguably mentally disabled. Do you waive your no pet policy in order to allow this person the enjoyment of this pet for the psychological comfort of her life? Who thinks we should enforce the no pet policy? I mean, is she really physically disabled? I mean, come on. I mean, who thinks, come on, enforce. The cameras aren't looking at you, they're looking at me. 1, 2, 3, 4, 5, 6, good, 7, 8. Oh, we got more people, come on. I know you want to raise your hand back there, come on. No questions yet. No. No clarification. All right. What's your question? He's moving in. No. He's living there. He's in your place, and now he's found this dog that's going to bring him extra comfort. Yeah, it's got a no pet policy. Yeah, absolutely. You got a contract with him. You got, hey, we've had offer, acceptance, consideration. You got a deal. Amen. You're gone. Are we going to give him a 3-day once he, are we going to give him a 3-day notice once he violates the act? I mean, not the act, the law? The lease? Sorry. Yeah? I mean, we got 8 people, 9 people, maybe more. Who's not sure? I'm just curious. I always can count on you. All right. Let me explain something to you. When we wrote the law, we being Congress, in 1988 about persons with disabilities, we weren't sure how many of these things were going to spin out, so we needed some guidance. And so we looked to another law that was actually passed in 1973, called the Rehabilitation Act of 1973, Section 504. Doesn't really apply to our situation here, but curiously, the language is identical in terms of the definitions and what's prohibited and what is not. Language is also identical in the ADA. And so, what you have to do is you have to actually look at the case law from Section 504 cases to see if this would be a reasonable accommodation. Bottom line, because you want me to go through all this crap. Sorry. Bottom line, you have to allow that accommodation. In fact, there's a fair housing case from 1997. Prentice Hall, Fair Housing, Fair Lending. That publication now is published by Aspen Hill. It's a good publication to have if you have $400 and you can allocate it as a business expense. But that was an example that was provided. Question? You have severe allergies? Well, then you could have well, and then you have a situation where you're making the argument that, well, allowing this accommodation places an undue hardship on the situation, on me. But I'll put it this way, sir. I'd be very comfortable representing the plaintiff in that matter. I'd be worried. I'd be sitting down with you in our conference room saying, look, we got a problem here. We got to resolve it, if I was representing you in that instance. So that's a situation. I've given some other examples of reasonable accommodations on page 18. Joy.